Hello, everyone. Welcome to today's Fridays with Vistage webinar. Before we begin, I'd like to go over some items to help you participate in today's webinar. If you are experiencing technical difficulties joining the webinar, please dial support at 888-259-8414. When you join today's webinar, you selected to join either by phone call or computer audio. If for any reason you'd like to change your selection, you can do so by accessing your audio pane in your control panel. During the presentation, all participants will be in listen-only mode. Please note that a PDF for today's presentation is available for download on your control panel. A recording of this presentation will be sent to attendees via email within the next week. I would now like to introduce the moderator for today's webinar, Bill Black.
Welcome to Fridays with Vistage. My name is Bill Black. I'm a Vistage member and speaker and your moderator for today's webinar, which is entitled Lawsuit Proof Your Business and Personal Assets. Your wealth isn't safe unless you protect it. This webinar will give you an introduction to the importance of asset protection planning and help you understand strategies that you can implement immediately to protect every single personal and business asset you own. Today's presenter is Vistage Speaker Ariel R. Enisman. She's an attorney and chief operating officer at the Presser Law Firm, a nationwide asset protection law firm that specializes in helping individuals and businesses in connection with the establishment of comprehensive asset protection plans. Ariel holds a law degree from Nova Southeastern University Law School, as well as a bachelor's in business administration from the University of Miami. Ariel joined the Presser Law Firm out of law school and has been with the firm ever since. She's been featured in major publications and is a member of the Florida Association of Women Lawyers and the Phi Alpha Delta Law Fraternity. She's also very active in many professional advisory committees throughout the South Florida. Ladies and gentlemen, I'd like to introduce Ariel Enisman.
Thank you so much. Good afternoon, everybody. Today what we're going to cover is asset protection. As Bill mentioned, the Presser Law Firm is a nationwide asset protection law firm. We're located in Boca Raton, Florida. We work with clients all over the country, specifically specializing in asset protection. So what we're going to cover today is some background information on what is asset protection. Then we're going to get into some asset protection techniques and tools for both business and personal assets. We're going to go through the 3 maxims of asset protection, the 4 basic strategies, and the 5 killer mistakes to avoid. Asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of any future potential threats and creditors. So our goal as asset protection attorneys is to work with individuals, to work with businesses, and we want to protect any asset that's worth any value at all from any financial threat. So the asset might be savings accounts, stocks and bonds, it could be real estate, could be shares in your corporation. And our goal is to protect any asset that you have worth any value at all from any financial threat. So whether it's divorce, whether it's foreclosure, mostly this day and age, it's lawsuits. A common question I get when speaking to Vistage groups is, well, do I really have enough assets to protect? And the short answer is absolutely. In fact, the less you have, the more you want to protect it. Think about it. I have a school teacher. She's saved up a few $100,000 over her lifetime, and she's now nearing retirement. Well, if she gets into a car accident and is sued for $1 million, that could be catastrophic. There could be no coming back from that. Contrast that with some professional athletes we work with that sign, very large contracts. If they're sued for $1 million, they're not happy, but certainly their lifestyle is not changing. The second common question I get is, well, what if I already have an asset protection plan in place? And that's great. And many of you listening might have already done some planning and have some basic strategies put in place. And I think that's fantastic because I love to hear that people are doing something. But no different than you go to the doctor every year and you have a physical. Well, you need a financial physical every year. The laws change, your assets change, your threats, your creditors change. So you need to make sure that what's working for you now is certainly going to work for you in the future. And one of the biggest misconceptions I see in my practice, and I get the call probably a few times a week, is don't worry, I put everything into a trust. I'm totally protected. In fact, I just got off a phone call where someone said that exact sentence to me. Well, most of the time, the trust that people set up and a lot of the trust that my clients set up are great estate planning tools. So the assets go where you want them to go after you pass away with the least amount of court costs and the least amount of estate taxes. However, today, while you're alive, those assets are not protected. So one of the biggest misconceptions we see is the difference between asset protection and estate planning. When people ask me, well, why do I really need asset protection? I like to show this cute little cartoon that appears on your screen. It's two lawyers talking. One says, I say Sue. The other one says, anyone in particular. And I can't hear you guys, but I usually get a few smiles and a few laughs. But, this is the truth. Just like you guys are smart enough to get together, a couple times a month and talk about how do you grow your businesses. You're smart enough to listen in today to get some knowledge. Well, this is what the lawyers are doing, except for they're not doing it every single day. I mean, they're not doing it every single month. They're doing it every single day, if not a few times a day. There was a lawsuit a few years ago against Subway because their footlong wasn't actually a footlong. It was about 11 and a half inches. Well, in that Subway case, people got back about 75 cents or so on their half of inch, and the lawyers made $35 million in between. So every day they're coming up with, who can we sue? The manufacturers, the business owners, the doctors, the car dealers. There's over 100 million lawsuits each year, and that number is growing. There is a 1 in 4 chance you will be sued in the next year. There's an average 5 lawsuits over your lifetime, a 50% chance of divorce, and really the key is a lawsuit can cost you tens of thousands of dollars even if you win the case. So one of the goals of asset protection is to discourage lawsuits. We want to put our clients in a position where they are such a difficult and expensive target that nobody wants to sue them in the first place. Because even if you're sued and you're not found liable, it is still expensive and it's opportunity cost. You have to be out of the office, you have to go to depositions, you have to hire an attorney to defend you. So we want to switch the question of liability to a question of collectability. Because at the end of the day, all that really matters is can someone collect against you? And if you put yourself in a position where it is so difficult and expensive to collect anything from you, well, people are not going to want to sue you in the first place because the judgment's not going to be worth the paper it's written on, even if they win. Liability insurance. A lot of people ask me when I give presentations, well, I have a large umbrella policy or I have liability insurance, isn't that enough? And I want to preface this slide with, I love liability insurance and our firm encourages our clients to certainly, have a liability insurance. It's relatively cheap and it certainly helps you sleep at night. Definitely gives you that peace of mind. And liability insurance is a great first line of defense. It's kind of like the plan A. Hopefully if you have a claim, the insurance company covers your claim. At the very least, they generally cover your attorney's fees. So again, the goal is to discourage lawsuits and have as many firewalls, as many layers of protection as possible. So liability insurance is that first line of defense, that plan A. However, with that said, liability insurance companies are some of the largest for-profit companies in the entire country. Their goal is they want to take in as much premium as possible and pay out as little claims as possible. 70% of lawsuits are not fully covered by insurance. So you need to be careful, and I'll give you an example. We had a client come in who got into a jet ski accident, and they had a $10 million umbrella policy that covered all boating accidents. So they came to my office and said, I'm not worried. I have this large umbrella policy, and it covers all boating accidents. Well, I'm sure you guys can all guess what I'm going to say next. Jet ski is not a boat. So unfortunately, they only had about $300,000 in coverage when they thought they had $10 million in coverage. Second point is that your coverage may be inadequate. Even if your insurance company does cover the claim, well, if you don't have enough insurance to cover the entire claim, who do you think has to come out of pocket for the rest? There's a chance your insurance company may go bankrupt. I'm sure if I said that 15 years ago, you guys would hang up the phone. However, now we have insurance companies going out of business. We even see Fortune 500 companies going out of business. And lastly, insurance does not cover other uninsured financial risks or divorce. So like I mentioned, insurance is the first line of defense, that plan A, but insurance alone is not the answer. If you fall into that 70% where your claim is not covered, what's your backup plan? Where is the plan B? again, we don't want our clients to ever be the low-hanging fruit where it's so easy to go after them and they're an easy target. We want to make them the difficult target, the expensive target. So you have the plan B, kind of what I call the suspenders to the belt, and that's the asset protection plan to supplement the insurance. So neither alone is truly the answer. Our 3 maxims of asset protection is number 1, protect yourself before you have a problem. It's very, very simple. If a client walks in my office with $1 million worth of assets and no lawsuits and no judgments, legally and ethically, we can protect that full $1 million. If a client walks in our office with $1 million worth of assets and they have no lawsuits and no judgments, and they have a $300,000 judgment against them or a lawsuit against them, well, legally and ethically, we can only protect the remaining $700,000. So you don't want to protect yourself after you have a problem. And if you think about it, it's no different than car insurance. You don't buy car insurance after the accident. It's no different than life insurance. You don't buy life insurance after you pass away. So asset protection is best done when you do it proactively before you have a lawsuit, before you have a judgment. Our second maxim of asset protection is start with a basic plan and add firewalls as needed. What is your largest financial asset? Maybe you start there. It's not all or nothing planning. You could do a little bit now, and then as your education grows, as your assets grow, well, so can your planning. But you don't have to do everything at once. You can start small, start with maybe your largest financial asset, and then build your plan from there. And our last maxim of asset protection is don't look for one magic bullet or one size fits all planning. Asset protection is very customized and very tailored. Each person has different assets. Each person has different threats and creditors. And so what works for one person is certainly not going to work for another. There's also a cost-benefit analysis, and there's also a risk tolerance involved with each person's planning. So you may need to make sure that any planning you do from an asset protection standpoint is extremely customized and extremely tailored to your needs and your assets. The 4 basic strategies of asset protection. This is very important. This slide, we're going to go over really what you can do from an asset protection standpoint, to give yourself a great foundation. In the middle, we have what's called exposed wealth. And exposed wealth simply means any assets that are in your personal name are exposed because if you're sued, you can lose it. So if you have real estate in your personal name, it's exposed because if you're sued, you can lose it. If you have shares in a corporation in your personal name, they're exposed and you can lose it. If you have a savings account or stocks and bonds in your personal name, they are exposed because if you're sued, you can lose them. So what do? One of our first strategies is transfer to a protective entity. And there's dozens of protective entities. I'm sure you've all heard of them. We have LLCs, limited partnerships, S corporations, C corporations, different types of trusts. And the way that it works is really, really cool. Each individual has their own social security number, and each individual has a different social security number. So if one individual is sued, well, they can't go after a different individual, and and vice versa. Well, your protective entity gets a tax ID number from the government, which is looked at like a social security number for an entity. And the law looks at you and your protective entity as 2 separate individuals. So if someone sues you, they can't go after your protective entity. And if someone sues your protective entity, they can't go after you. I don't make up the laws, I just follow them. This is what the law says. So why not take those exposed assets that are sitting in your personal name and transfer them to protective entities where now if you're sued, nobody can touch them. So just to go over a few assets that we would transfer to a protective entity, and I'm not going to go over all of them, but just going to go over, some very common ones. We can discuss real estate. Real estate is a great entity to get if you have sitting in your personal name to transfer to a protective entity. Anytime you have a piece of real estate besides your primary home, it should be titled in the name of an LLC. So if you have a rental property, if you have a vacation property, an investment property, land, any piece of property that is not your primary home, it should not be titled in your personal name. It should not be titled in your revocable living trust. Rather, it should be titled to an LLC. And there's 2 reasons why. Number 1 If you own a piece of property in your personal name today and you get sued personally, that is an asset of yours and somebody could take your piece of property. Number two, if somebody gets injured on your piece of property and they slip and fall or something happens, well, they can now sue the owner of the piece of property. So if you own the piece of property in your personal name, now someone can sue you personally. By putting it in an LLC, you get rid of both of those problems. Well, now number one, if someone sues you personally, you no longer own the piece of property. It's owned by an LLC, so now nobody can touch your piece of property. Number two, if somebody gets injured on the piece of property, well, they're going to sue the owner. You no longer own it personally, so they can no longer sue you personally. All that somebody can do is sue the LLC, the owner of the piece of property, and they can get any assets that are in the LLC. And that's why I say if you have separate pieces of property, you want a separate LLC for each property. So if you have one piece of property, you'll have one LLC. If you have two pieces of property, you'll have two LLCs. And if you have three pieces of property, you'll have three LLCs. Now, certainly there's a cost-benefit analysis, and again, each plan would be customized and tailored depending on the value of the asset. But as a general rule of thumb, anytime you have a piece of property, you want your own separate LLC. Your primary home is a little bit different because if you put your primary home into an LLC, you lose the potential $250,000 capital gains tax deduction when you go to sell your house. So a couple of questions you'll want to ask yourself before putting your primary home into an LLC. The first question you'd want to ask yourself is, well, do I ever plan on selling my house? If the answer is no, I do not plan to sell my house, well then sure, put it in an LLC. If the answer is yes, I may sell my house, well then you're going to want to ask yourself, am I ever going to make a profit? If the answer is yes, I might make a profit, well then you'll ask yourself, do I want the tax benefit or do I want the protection? If the answer is no, I'm not going to make a profit, well then again, sure, put it in an LLC. So again, it's very customized and very tailored to each specific situation. But as a general rule of thumb, like I mentioned, anytime you have a piece of property other than your primary home, you'll want to put it in an LLC. The other thing that we commonly use LLCs for are your businesses. Anytime you have a business, and I don't care how big or how small your company is, you want to make sure that you have an LLC. And having one LLC is no longer good enough. If you have different divisions within your business, so for example, a manufacturer that does online sales, retail sales, or wholesale sales, if there's different divisions within the company, each one of those divisions should be its own separate individual entity. So the manufacturer that has three different divisions would have three separate companies. Or a builder who has a building aspect to their company, an interior design aspect to their company, and an architecture aspect to their company, those three divisions, again, would be three separate companies. Because think about it. If the builder, if something happens on the job site in his construction part of his business and somebody gets hurt, well, why should they be able to go after his interior design business or his architecture business? Or the manufacturer. Well, if something happens to somebody in the retail space, why should a creditor be able to go after his online business or his wholesale business? So if you have different divisions within your company, they should each be their own separate individual entity. And not only just from a liability standpoint, but this also allows you to find out exactly which division of your company is doing what. So a lot of times I'll have business owners come to me and they have one operating company and, I look at them like they're crazy and they look at me like I'm crazy, but they know their bottom line and they know is doing well and they know they're profitable, but they're not exactly sure which division is more profitable than the next. So by separating each individual division into a separate company, well, now you'll know exactly which division does what, which division is profitable, maybe which division is not as profitable. And let's say you want to start something new or you want to try a new division. Well, if God forbid it fails, now it doesn't wipe out your entire company. Also think about the future. Well, by separating out the divisions into separate companies, you've now given yourself the flexibility in the future to sell all of your business or just sell part of your business. So, for example, if the builder wants to sell his construction portion of his business because there's a lot of liability and it's, he's trying to wind down, well, he can sell that part of his business and he can keep the interior design aspect to his business as well as keep the architecture aspect to his business. So not only from a liability standpoint, but also from a profitability standpoint and a flexibility standpoint in the future, separating your business into different divisions has a lot of benefits. The next thing I want you to think about with your business is not only separating by division, but also separating out by the assets. So think about what assets are inside your business that your operating business could not operate without. So for example, it could be machinery, it could be equipment, it could be inventory, it could be intellectual property, it could be any asset that you need to operate. It could be the real estate. If you have any assets sitting inside your operating company that you need to operate, you need to get them out of your operating business. The operating business should not directly own any assets, because not even if anymore, but when an operating business is sued, if you have all of the assets sitting in one operating company, well, now a creditor can go after everything the operating business owns. So again, the operating business should not directly own any assets. So you might want to consider creating a separate entity for each asset and leasing those assets back to the operating company. So now if the operating business is sued, well, there's no assets sitting in the operating business, and you could start a new operating business and release all of the assets. So the goal would be to protect the assets that you need to operate. That way you never go out of business. Moving on from the business, the other thing that we might consider using LLCs for would be any toys. So boats, planes, wave runners, anything that produces risk, you may want to consider getting out of your personal name. Because if there's anybody else that were to drive a boat or operate a plane or drive a jet ski, well, God forbid they get into an accident. If you own that asset personally, now you will be personally liable. So one of the keys of asset protection is really to own nothing, control everything. Because now you can see if you own something, it's exposed, and if it's exposed and you're sued, you could potentially lose the asset. On the other flip side of toys, anything that's worth a lot of value. So arts, antiques, jewelry, because again, if you own any valuables in your personal name and you're sued personally, well, that is an asset that you own and it's an asset that you can lose. So you always want to think about things both what I call inside out and outside in. If there's an accident or if there's a risk produced within the asset, like a boat or someone slips and falls on a piece of property, well, if they go after the owner, you want to make sure you do not personally own that asset so that you are not personally liable. And again, the other way around is if you own assets personally and you're sued personally, you want to make sure that no one could touch those assets.
Ariel, while we're on this topic, we have one question that I thought might make sense for you to answer now.
Sure.
Okay, the question is, I have a large rural recreational property for hunting and other activities, and I do have a waiver that I use for guest hunters, but should I consider placing that property inside an LLC?
Absolutely. Like I mentioned, any time you have a piece of property, you want to put it in an LLC. And the reason being is, certainly a waiver is a great first step. However, if something were to happen on the piece of property, so someone comes over and they get injured or something happens, it will not stop them from suing you personally. And, depending on whether the waiver holds up or not, you've still put yourself personally at risk. By putting it in an LLC, you've taken your personal liability out of the equation altogether. Now, if something happened on the property, they'd only be able to go after the owner, who is an LLC. So certainly any time you have a piece of property, no matter what kind of property it is, you want to put it into an LLC. Our second strategy that we have here is protect with liens. It sounds crazy, but poverty is power. What do you guys think any lawyer does before they go sue you? Well, they look you up. They do an asset search. So what's $1 million house worth if you owe $950,000 on it? Or what's a $50,000 car worth if you owe $45,000 on it? So you can actually use liens, mortgages, encumbrances to make your assets look as valueless as possible. If your business needs new equipment, you could take out a loan, file a UCC security agreement, and now you'd be the first creditor in line. So if something happens and the business goes under, well, you've got to pay yourself back first. Or your primary home or even a second piece of property. You could take out a home equity loan, so it shows up as a mortgage when someone goes to Google you, but you don't actually need to pay a penny towards it until you pull from it. So you can have it sit there and it shows up as a mortgage, and again, a way to discourage lawsuits because it shows like there's very little value or very little equity in the asset, and it doesn't cost you anything to do something like this. A lot of clients will make the banks and the financial institutions their best friends. So, they'll increase the line of credit on the business. They'll take out a home equity loan. So certainly the bank is happy because they're hoping one day you'll pull from it. And you've put yourself in a good position because you've discouraged lawsuits. You've made yourself look like not the easy target. You've made yourself not the low-hanging fruit because, again, the goal is to make yourself, look difficult and expensive to collect against. I also have clients that will act as their own bank. They'll borrow money from a protective entity that they own that has cash or something liquid in it. And they'll buy an asset, whether it's a home, whether it's a car, whatever it might be, and they'll put a lien from their protective entity on the asset. So they're really acting as their own bank. They're borrowing money from themselves, a protective entity, and then they'll put a lien from their protective entity on the asset. So you can either act as your own bank, you can use major banks and financial institutions, but basically stripping the equity and stripping the value out of the assets makes you look like a less vulnerable target. The third strategy we have is convert into exempt assets. And exempt assets are simply assets that are exempt by state law. And each state has different assets that the law says if you put your assets into these certain vehicles that a creditor cannot touch them. And these laws vary by state to state. So if you're curious what's protected in your state, if you go to my website, www.assetprotectionattorneys.com, on the left-hand side, there'll be a button called Financial Planning Exemptions. And if you look by your state, it will have what's exactly protected in your state. So some of the common protections would be your home, life insurance, retirement accounts, potentially annuities. So again, you can look at what's protected in your state. And the reason this is interesting is because it may give you a roadmap of maybe where you do and don't want to put your assets. So for example, if you live in a state where your home is totally protected, well, maybe you pay off your mortgage because it doesn't matter. Nobody can take your house. But if you live in a state where your home is not protected by state law, well, maybe you're not so quick to pay off your mortgage, or maybe you do take a home equity line out on your house and use one of our other strategies to protect the home. Or maybe if you live in a state where your retirement is totally protected, then you put more money into your retirement. I'm not your financial advisor. I'll certainly never tell you where to put your money, but these exempt assets give you a roadmap of maybe what you do and don't want to do with your assets. And our last strategy that we have here is transfer all ownership rights. And this really deals with own nothing, control everything. So like I mentioned earlier, as you can see here, if you own something, it's exposed and you could potentially lose it. So the goal is to own nothing, control everything. So what you really want to focus on is who benefits from the asset and who controls the asset, less so than who actually owns it. So you want to get those ownership rights out of your personal name, whether it's moving them to protective entities, moving them to exempt assets, but you don't want to personally own anything. The 5 biggest mistakes that we see are, number 1, hiding your assets. A lot of times people think that asset protection is about hiding or it's about secrecy. And in fact, it's not at all. It's really about protection. I tell my clients, presume one day someone's going to sit you down for deposition. They're going to ask you, what do you have? Where is it? And you're never going to lie. You're never going to perjure yourself. So the goal is that you'll tell them everything you have. You'll tell them exactly where your assets are. They just can't get it. Again, we want to switch that question of liability to the question of collectability. At the end of the day, can someone collect against you? Because if someone can't collect, Well, the judgment's not worth the paper it's written on. And if someone goes to hire one of these contingency lawyers, it doesn't cost them anything to sue you. Well, a contingency lawyer is not going to take a case if at the end of the day they can't collect and they can't make money. So if you put yourself in a position, you'll get rid of a lot of these frivolous lawsuits, a lot of these people that are going to sue you because it doesn't cost them anything to sue you. Titling your assets to straws. You don't want to title anything to someone who you think has less financial troubles than you do. Just a quick story. We once had a client come in. He came in our office and he said, I'm being sued, but don't worry. I transferred everything to my best friend. And we looked at each other like, what actually makes you think your best friend has less legal and financial troubles than you do? Well, the best friend got sued and the best friend got divorced and the best friend's ex-wife took half of his assets. So you don't want to transfer assets to who you think might have less problems than you do. No different than titling your assets to your spouse. I see this mostly with my doctor clients. They'll transfer everything to who they think the less vulnerable spouse is. And if you think about it, nobody wakes up in the morning expecting to be sued, and certainly nobody's immune from a lawsuit. So you could transfer everything to your spouse thinking they're less vulnerable, and they're taking the kids to soccer practice, they get into a car accident, and there go all of your assets. So you don't want to transfer your assets to who you think is less vulnerable, because at the end of the day, anybody can be sued. Number 4, we don't want to commit any fraudulent transfers. And fraudulent transfers deals with transferring assets after you have a problem. So a fraudulent transfer is a transfer for less than fair market value against a present or potential creditor with the effect the creditor doesn't get paid, with the intent to hinder, delay, or defraud the creditor. So really in layman's terms, if you transfer any assets and you have a present or potential creditor and you receive less than fair market value in return, it's a fraudulent transfer. So you don't want to commit any fraudulent transfers because ultimately the court can unwind these. So any time, money, effort you spend into transferring your assets after you have a problem ultimately can be unwound by the court. And lastly, you don't want to break any laws. Might sound very simple, but you want to be very careful when you're setting up any type of structure, when you're doing anything from a legal perspective, especially when it comes to international planning. Our law firm offers both domestic and international asset protection planning, and there's absolutely nothing wrong with doing international asset protection. However, there's something very wrong with doing it and not reporting it to the U.S. government, not reporting it to the Treasury Department. So you want to make sure that you don't break any laws and that everything you do is 100% legal, 100% ethical. Another strategy that we have is titling your assets tenancy by entireties. And tenancy by entireties is a way that you can title assets, which is available for living married spouses. It's available in 25 states. And again, if you go to our website, assetprotectionattorneys.com, on the left-hand side, you'll see a tenancy by entirety button, and that will let you know if your state recognizes tenancy by entirety. What tenancy by entirety states is that the assets of both spouses are not subject to the creditor of one spouse. So, for example, if spouse 1 has $100,000 in their personal name and they're sued, we already know that they can lose it. And if spouse 2 has $100,000 in their personal name and they're sued, we already know they can lose it. So if spouse 1 were to take their $100,000 and spouse 2 were to take their $100,000 and they put it together in an account labeled tenancy by entirety, well, now if spouse 1 is sued, they can't touch a penny. And if spouse 2 is sued, they can't touch a penny. The only way a creditor can get these assets are if both spouses are sued for the same cause of action, which is much more rare than one spouse being sued individually. So it's a great extra layer of protection. It does not cost you anything to own assets tenancy by entirety. So you could own real estate tenancy by entirety. You can own personal bank accounts tenancy by entirety, certainly as long as your state recognizes that. It's not the end-all, be-all of protection because upon death or divorce, there's immediate exposure upon the asset. So if you have a death or you have a divorce and you have a creditor, well, that creditor can now immediately go after the asset. So I like it as an additional layer because, again, it doesn't cost you anything to own assets this way. However, it's not the end-all, be-all because, again, there could be exposure should something happen. Corporations. Corporations are often one of the areas where we see some misconceptions. So C corporations have the double taxation. However, from an asset protection standpoint, anyone or any entity can own shares in a C corporation. So it's very easy to protect shares in a C corporation. S corporations, although they have the great tax benefits and some other benefits as you have less than 75 shareholders, from an asset protection standpoint, it is my least favorite entity because it is very difficult to protect shares in an S corporation because the IRS has limited who can own shares in an S corporation. So just to take a step back for a second, the reason that anybody were to set up a corporation and you don't own your business in your personal name is corporations are great to protect yourself from any bad business debt. If something happens in your business, personally, you are not liable. However, what most people don't think about is the other way around. If you own shares in your corporation, it's terrible to protect your personal assets. So, for example, if you own shares in an S corporation or if you own shares in a C corporation in your personal name and you get sued personally, it is no different than owning any other asset in your personal name. So if you're sued personally and you own shares in a corporation, a creditor can take those shares in your corporation. If you own more than 51% and a creditor gets 51% of the shares in your company, well, now they can hire, they can fire, they can liquidate the bank accounts, they can literally take over your business. In fact, we've seen businesses go out of business, not because they've done anything wrong, because the majority shareholder was sued personally. So it's very important to think about how to protect your shares in the corporation. And there's many different strategies to protect both C corporation shares and S corporation shares, depending on state laws, depending on how many shareholders. So there's a number of strategies, and certainly you can protect your shares in both S corporations and C corporations, no different than you can protect your interest in an LLC. And the LLC is really the best entity to have today for a number of reasons. Well, number one, the LLC has the same flexibility in terms of ownership that the C corporation has. So anyone or any entity can own your interest in an LLC. So it's very easy to protect your interest in an LLC. The second reason the LLC is the best entity to have is an LLC can be taxed however you want. So it's very flexible in terms of its tax status. So for example, an LLC can be taxed as a disregarded entity. It can be taxed as a partnership. You can tax it as an S corporation. You can even tax it as a C corporation. So it's very flexible in terms of taxation. And the third reason, and really where the protection comes from, is state law. State law has made it much more restrictive to take your interest in an LLC than shares in a corporation. In fact, some states have said that no matter what, a creditor cannot ever take your interest in an LLC. Other states have said the exception to that might be foreclosure, might be bankruptcy. But there's very limited ways for a creditor to take your interest in an LLC, whereas your shares in a corporation have no restrictions at all. So again, if you're sued personally and you own shares in a corporation, a creditor can take those shares and there's very little restrictions, very little limitations to them taking the shares in your corporation. Another strategy and another entity that we use, and going back to using protective entities, could be a limited partnership. And the limited partnership is one of the most protective entities that we have inside the United States. In fact, it's probably the most protective entity that you can create inside the United States. And the reason being for that is it's been around for a very, very long time, probably close to 100 years or so. There's tons of case law on it. It's very black and white. So we use the limited partnership to protect any safe assets. And what I mean by safe assets are any assets that don't spin off any litigation. So for example, any and all liquid assets would be protected by a limited partnership. So if you have stocks and bonds, savings accounts, money markets, CDs, checking accounts, any liquid assets that are in your personal name are obviously exposed, and if you're sued, you can lose them. So one of the common strategies we'll use to protect liquid assets would be a limited partnership, which again is the most protective entity that you can have inside the United States, and we use to protect safe assets. The LLCs, which we talked about a few minutes ago, we use to protect any what I call dangerous or business activities. So anything that produces liability or could potentially produce a lawsuit. For example, the real estate, the businesses, the toys. So anything that is risk producing should be structured in its own individual LLC. Moving on to international planning. So far we've talked about pretty much all the domestic strategies that you can have inside the United States and how to protect certain assets inside the United States. And a lot of those strategies are very, very great and, can get a client very, very protected. However, I would say you could probably get somewhere between 80 and 90% protected using U.S. domestic strategies. And unfortunately, I don't give it more than that just because sometimes the laws in the U.S. are a little bit gray. Sometimes judges rule based on emotion. They don't like you. They don't like your attorney. However, to get to 80, 90% is fantastic because most of my clients come to me and they're probably 10, 15% protected. So to make a jump to 80, 90% is really, really great. But if a client wants a little bit additional protection, and I'd never call it 100%, but I'd call it 99.9% with a bar over it, we'll use some international strategies. And I'm just going to give you guys a quick example of what you would need to do to get to one of my clients who has an international trust set up. The first thing you would need to do is sue my client and beat them in the United States. Because if you don't sue them and beat them in the U.S., legally, they do not have to tell you where their assets are. But you sue my client, you beat them in the United States, you sit them down for deposition, and hopefully you hire a really good attorney that knows the right questions to ask, that finds out that you have a trust called in the Cook Islands. And there's better jurisdictions, but I was recently reading an article on it. So you fly to the Cook Islands, which, by the way, there's one flight a week from California. It's a 15-hour flight, and you're stuck there for a week. And so you fly to the Cook Islands, you've got your U.S. judgment, you're ready to collect. Well, they're going to throw it in the garbage because they don't recognize U.S. judgments. So now you'll need to relitigate your entire case in the Cook Islands. So you'll go to hire an attorney in the Cook Islands, and you'll find out very quickly that the few attorneys they have there will all be conflicted off the case because they work with the attorneys like myself or the other trust companies. So maybe you'll fly to the closest country, call it New Zealand, and you'll go to hire an attorney there. Well, here in the States, it's very easy to hire an attorney. You can get one pretty much at no cost at all. Where we set up these international entities, they do not recognize contingency fees. So now you'll need to pay your U.S. attorney hourly and your New Zealand attorney hourly to fly back and forth to the Cook Islands to relitigate the entire case. Well, you hire your attorneys, you're there, you're ready to sue. You better hope that all of this happens within the statute of limitations, which is anywhere between 0 and 2 years. So that means your U.S. case had to take less than 2 years for you to even be eligible to sue. But you have the fastest U.S. case, you have your attorneys, you're ready to sue. Well, now you have to post a bond, half of what you're suing my client for. So if you're suing my client for $5 million, you have to post a $2.5 million bond because when you lose, you have to pay our attorney's fees. But you post your bond, you're ready to sue. Well, now you have to prove the case beyond a reasonable doubt, which means you need more evidence to get our client's money than they need to put Casey Anthony in jail. And lastly, any good asset protection attorney will include in our 150-page trust agreement what's called a Cuba or a flee clause, which allows us to relocate the assets at any time. So while you're doing this whole thing in the Cook Islands, we've already moved all of the assets to Nevis, Belize, Switzerland. You got to do the whole thing all over again. Less than 3% of these entities are challenged, not beaten, but challenged because it is so difficult and expensive, if not impossible, to get the money. The only people you see that go after it are the IRS, the FTC, the major governmental entities. International LLCs we use mostly to protect cash and accounts receivable in your business. So, we talked about stripping out the assets in the business, equipment, inventory, intellectual property. We talked about some of that earlier and how your operating business should not directly own any assets. However, sometimes clients cannot strip out the cash of their business or they have a large amount of accounts receivable. If this is the case, then international LLCs are a great tool to use to protect that. And essentially, the international LLC will be a subsidiary LLC to your domestic operating business. So it's not going to change the books, not going to change anything from a tax perspective. The only difference is that you now have a place where you can move cash or accounts receivable to an internationally, where because of the example I just gave, it is much more difficult to get at. So thank you guys so much for attending today's webinar. I just wanted to go over really the basics of asset protection, a couple of the strategies hopefully that you can implement and take away immediately from today's presentation. Certainly, if anyone's interested in getting more information, I do offer a 3-hour Vistage presentation to the individual group. So if you liked what you heard today, I'd be happy to come give the full presentation to anyone's group. Just let your chair know or reach out to me. Also, we offer complimentary copies of our latest books on asset protection to anyone that attended the webinar today. So if you'd like copies of our books, certainly feel free to email me at ae@assetprotectionattorneys.com, and I'd be happy to get those out to you. Also, as Vistage members, we offer complimentary consultations to anyone that would like a little bit additional information about their specific situation. Certainly, if you're interested in having a complimentary consultation, again, feel free to call or email me at ae@assetprotectionattorneys.com, and I'd be happy to schedule something of that nature. I will take any questions that you guys have today. Please feel free. Probably one of the times you can ask an attorney questions and not get billed, so I would definitely take advantage if I were you guys.
Good point, Ariel. Yeah, for our listeners, you can put your questions into the toolbar on the right-hand side of the screen. We do have a few questions for you, Ariel. One of them is, and you mentioned some of this, but I'm confused at what state should I use for my LLC? I hear about Delaware and Nevada and other different states. Do I use different states for different assets?
Absolutely. Depending on what the asset is, will determine where we would set up an LLC. So, for example, a piece of real estate, the LLC will need to be located wherever the piece of property is. No different than a business. If it's more of a holding company, we'll have additional options of where we would like to set up an LLC, and certainly we'll determine what the best asset protection jurisdiction is, where the best asset protection laws are, and the states vary from they change their laws, they tweak their laws every couple of years. So really we would have to determine what the asset is, and then determine where the best asset protection jurisdictions and laws are. You obviously hear of the few good ones: Delaware, Wyoming, Nevada. And again, they tweak their laws every couple of years because they want the revenues.
Excellent. Now, you mentioned just a few minutes ago about offshore trusts, so you may have covered this, but the question is, I've heard a lot about offshore trusts, but I've also heard the government is attacking them. Can you address that side of things?
Sure. We're actually very conservative with setting up our international entities. In fact, we actually get a U.S. tax ID number for each one of our international entities. That way, we're basically saying to the government, hey, government, we're creating this entity. We're not looking to evade taxes. We're not looking to, do anything illegal. This is set up. You know about it. We're going to file all the reportings. We're going to file all the regulations. We're basically setting this up for protection. So we do it in a very conservative way. As I mentioned, you have to make sure you do everything 100% legal and ethical. We don't want to have any issues, so we don't run any of those risks. We do things very, very conservatively. Like I mentioned, there's nothing wrong with asset protection. There's something very wrong with doing it and not reporting it to the U.S. government or the Treasury Department. So as long as you follow the guidelines and you follow the regulations, there's no issues whatsoever.
Terrific. Another question we have here is, how do my retirement accounts fit with my asset protection plan?
So retirement accounts are one of the assets that may or may not be exempt by state law. So again, certainly if you look at the website and what's protected in your state, if your retirement accounts are protected today in the state that you live in, today you would not move them. However, what's important to note is future retirement planning, because when you pull from your retirement accounts, although they may be protected, when you pull from them, that money is no longer protected. So the retirement laws vary state by state in terms of what's protected, what's not protected, and then certainly after you pull from those retirement accounts, even if they are protected, that money is no longer protected, and we'd want to consider how to protect that as a liquid asset.
Thank you. Okay, we have another question coming in. I have my investment accounts in a separate LLC. What directions would you give me to make sure that those investments stay safe in case there's a personal claim against me?
I'd have to look to see exactly how the assets are titled, how the LLC is created. Is it single member, multi-member? Where is it located? So we'd have to take a look at that, individually and specifically. But certainly owning the assets not in your personal name is a great first step, because like you saw today, anything you own in your personal name is obviously exposed if you were sued personally. So you might have things set up properly. You might need to tweak, a little bit here and there. It's very difficult to tell without, looking in specifically at how they're titled and how the LLC is created. But, certainly getting them out of your personal name is a great first step.
Terrific. And along those lines, you suggest to get all your toys out of our personal name, while all of my business and companies, restaurants and real estate, are in individual LLCs. My jet skis and boats are in my individual name. How are these toys typically placed into LLCs since they're not company-owned assets?
Yeah, no different than you would transfer any asset into an LLC. So certainly the title, rather than being in your personal name, the title on your boat would then be transferred to an LLC. And again, it's very important to think about that because, if anybody else drives your boat or something were to happen, if it's in your personal name, you could be sued personally. So, it's pretty easy to transfer assets into an LLC. You're really just changing the title, rather than it being in your personal name into the name of an LLC.
Okay. Here's a question. It sounds like somebody who might be exasperated by all this planning. Is there just a plan for everyone?
No, there's not. Like I mentioned earlier, it all needs to be very individualized and tailored. So not sure if your question meant, is there just a, basic plan for everybody? But, certainly everybody needs to do planning and everybody can use asset protection planning, but there's no one size fits all planning. Like I mentioned, and, from some of the questions that you've heard, everyone has different assets. Everyone has different threats and creditors. So you have to make sure that whatever you put in place will certainly work for you and will really protect the assets that you have.
Good point. Another question. I've heard something about LLCs that have several divisions or cells to them. Is that a possible or I guess it's is that a potential strategy?
Sure. I believe you're referring to what we call series LLCs. And series LLCs are relatively new in the legal world. They've probably only been around for maybe 10, 15 years or so, or really utilized in the last few years. Because they're so new, it's not generally a strategy that I like to use just because there's so much changing case law. There's case law that goes both ways. They've been proven, and then there's cases in which they've been broken through. I never like my clients to be the guinea pig for, any of these strategies. So really until something is really proven and it's really black and white, it's generally not a strategy that I use. So I'm not a big fan of the series LLCs just because of the, ever-changing case law and, the lack of provenness that they really uphold in the court.
Okay, we have one more question here. It looks like, what is the first step to working with you and your firm?
Sure, I would recommend setting up a complimentary consultation, either with myself or with one of our managing partners. That way we can kind of get the 30,000-foot overview of your specific situation, and give you a little bit more guidance on, how to best protect your assets and how to best move forward with, the planning. Certainly you can give us a call or email me. I believe my email was up on one of these slides, but it's ae@assetprotectionattorneys.com. That's our toll-free number on the screen. Our local phone number is 561-953-1050. And you can always visit our website as well.
Thank you, Ariel, very much for a well-done presentation. You covered a lot of ground and very clearly and gave us some very actionable tips. So thank you very much for that today.
Thank you very much.
And I want to remind you, listeners, that we have some upcoming webinars on Friday, November 2nd, 2018, Building Culture and Engagement in Virtual Teams. And on Friday, November 16th, 2018, Artificial Intelligence, Implications for Small and Mid-Sized Businesses. On behalf of Vistage Worldwide, this is Bill Black wishing you continued success. Thank you so much for joining us today. This concludes today's Fridays with Vistage webinar.